Assalamualaikum warahmatullahi wabarakatuh to our beloved Dr. Hazmi. We hope you'll be fine. Me and my group members want to present a case citation from article newspaper. So let's start from the first case. The first case is about Safwan Anang case. We have found two article newspaper that cover Safwan Anang case. Okay, Muhammad Safwan Anang, he is a former chairman of Student Solidarity Malaysia, SMM. He was 25 years old at the time of the case. Okay, this case started and occurred when he gave a speech in his talk on 13th of May 2013 between 8:55 p.m. and 11:15 p.m. at Kuala Lumpur and Selangor Chinese Assembly Hall, Jalan Maharaja Lela, Dangwangi, where his speech tend to be seditious. Safwan Anang has been accused that his speech more to arouse the anger of the people of this country to change the government established according to the law in an illegal way. Okay, based on the reason that given by Safwan Anang, where he only criticized and expressed dissatisfaction with the result of the 13th general election that have been held in 2013 and the Election Commission, EC. The relation of this case to communication law is it is an offence to seditious. Safwan Anang was found guilty under the Sedition Act of 1948. The Sedition Act criminalized any speech, words, publication, act with seditious tendency. So, any person in this country, when they give any speech, publish anything that have seditious tendency, they can be found guilty under the Sedition Act of 1948. They have a few laws that relate with this case. Okay, first, the charge made on Safwan Anang case is in accordance with Section 4, Bracket 1, Bracket B of the Sedition Act 1948, which is state anyone who says whatever words that are commit to seditious. Next, the situation of case also can be related with Section 3, Bracket 3 of Sedition Act 1948, which is a person's intention is irrelevant to prove he is guilty under this act, as long as he tends to seditious tendency. Other than that, he also can be punished under Section 4, Bracket 1 of the same Act, which carries a fine of up to 5,000 ringgit or imprisonment for up to 3 years or both if he has been convicted. So, Safwan Anang has been convicted under this Act. He had been punished to 10 months in prison by a session court. This punishment was made by Judge Nordin Awang, where Safwan Anang was ordered to serve the punishment on 5th of September 2014. Then this case is followed by an appeal process in the appeal court, and it takes times for that process. Okay, the result of this case that state in newspaper article, in 2014, Safwan Anang was be guilty under Sedition Act 1948, and he has been punished to 10 months in prison. He also was fined 15,000 ringgit, which has increased by the judge from 5,000 ringgit to 15,000 ringgit. However, Session Court Judge Nurnajwa Awang allowed the accused application that represented by his lawyer Arif Azami Hussin to postpone the punishment of the imprisonment while waiting the appeal in the High Court. He also was released on bail of 15,000 ringgit and paid by his guarantor. And finally, this case in 20 of December 2016, the Court of Appeal has decided to acquit Muhammad Safwan Anang from sedition accusation. The decision was read by the judge of the appeal court, Datuk Dr. Prasad Sandosham Abraham. He explained that the court needs to test objectively whether Safwan's statement has a seditious tendency or just a purely political comment. And then the appeal court has proved that the statement of Safwan Anang has no seditious tendency. And then the party who claimed the Safwan Anang case failed to prove a prima facie case against him in the session court. And finally, Muhammad Safwan Anang was released from this case.
My name is Nadzirah Binti Hussin. My matric number 1180177. My case citation is Karpal Singh versus Sultan of Perak. Do you know who is Karpal Singh? His name Karpal Singh, son of Ram Singh. He was born on 28 June 1940 until 17 April 2014. He was an Indian Malaysian politician and a lawyer. He was a member of parliament for the constituency of Bukit Gelugu in the state of Penang from 2004 until 2014. And during that time, he was also the national chairman of the Democratic Action Party, as known as DAP. We move to fact of the case. Okay, in this case, Karpal Singh was charged with uttering seditious words against the Sultan of Perak at his legal firm in Jalan Pudu in Kuala Lumpur between noon and 12 p.m. on 6 February 2009. He was voiced his opinion, the removal of Minister Muhammad Nizar as Menteri Besar by the Sultan of Perak was ultra-vires the Sultan's authority and could be reviewed by court. And then the High Court found that Karpal Singh guilty of sedition for questioning the Sultan of Perak had the tendency to create hatred towards Sultan. On March 11 has been set a new date by the High Court for mitigations and sentencing a lawyer Karpal Singh after being found guilty. And this case under Section 4, Clause 1, bracket B of Sedition Act 1948, which is carries a maximum sentence of 3 years imprisonment, a fine RM 5,000 or above, or both. Then the High Court acquired and released Karpal Singh from the charge on June 11, 2010. However, the Court of Appeal on Jan 20, 2012 ordered the lawyer to defend himself after following the prosecution's appeal. What's relation to communication law? Okay, in communication law, I learned a few of acts from this case. First, Freedom of Speech and Expression, and second, Sedition Act 1948. Okay, first, Freedom of Speech and Expression. This is under Article 10, Clause 1A, provides for every citizen with freedom of speech and expression, and Article 10, Clause 2A of the Federal Constitution that intended to protect the privilege of Parliament or the state's legislature, or to make provision against contempt of courts as provided. Okay, although we have freedom of expression, we also have to duty to behave responsibility to protect other people's rights for our public safety and reputation for other people. We move to second, Sedition Act 1948. Okay, this act under Section 3, Clause 1, bracket A, is seditious tendency. What is tendency? A tendency is referred to bring in for hatred or contempt or to excite disaffection against any ruler or liable for a first offence to a fine not exceeding 5,000 or to imprisonment for a term not exceeding 3 years or above under section 4 clause 1 bracket B, which is utters any seditious words. What's law related to this case? Okay, I found 3 law that's related to this case. First, freedom of speech and expression. Second, Sedition Act 1948. And third, Legal Profession Act 1976. Okay, first, freedom of speech and expression. Like I said before, this is under Article 10, Clause 2, bracket A of the Federal Constitution that intended to protect the privilege of Parliament or the state's legislature or to make provision against contempt of courts as provided. Okay, in this case, the transcript that was said by Karpal Singh to the press conference is, he said, I have stated very clearly that we will sue the Sultan together with new state government as defendants if they persist. Okay, from this statement show us it is to create hatred to the Sultan. Okay, then we move to Sedition Act 1948. Okay, the charge under Section 4, Clause the charge under Section 4, Clause 1, bracket B of the Sedition Act 1948 was for allegedly uttering speech deemed to incite hatred, contempt, or disaffection against any ruler or government. In this case, the evidence is Karpal was questioning the power of Sultan Perak regarding the abortion of Datuk Muhammad Nizar as Menteri Besar of Perak in 2009. Then the third law is Legal Professions Act 1976. This is under Section 94, Clause 2, refer to advocate and solicitor who has been guilty of any misconduct shall be liable to be struck of the role or suspended from practice for any period not exceeding 5 years. Okay, in this case, Karpal was get the sentencing a fine 5,000 and 3 years imprisonment. So the conclusion of the case, Karpal Singh was charged under Section 4, Clause 1, bracket B of the Sedition Act 1948, which carries a maximum sentence of 3 years imprisonment and a fine 5,000 ringgit or above. Under Federal Constitution, Karpal Singh faced the risk disqualifications as a member of Parliament if fined more than 2,000 or imprisoned for more than a year. Then, in 2016, the Court of Appeal by a 2-1 majority decisions upheld his conviction but reduced the fine to from 5,000 to 1,800 only under Section 94 Legal Profession Act 1976. Then Karpal Singh was died on 17 April 2014 in a car accident on Lebuh Raya Utara Selatan near Gua Tempurung, Perak. After 5 years he died, the federal courts acquired and cleared the good name of the late Karpal Singh from charge the Sedition Act for allegedly questioning the actions of the late Sultan of Perak in relations to be crisis in the state of Perak. So that's only from me.
My name is Nurnajwa Binti Nordin. My matric number 1180178. Okay, my cases is Teresa Cockwin's defamation suit awarded 80,000 damages. Who is Teresa Koch? Teresa Koch Hussin is a Malaysian politician. She is the incumbent member of Parliament for Seputeh constituency from the Democratic Action Party. It is the AP, a component in the Pakatan Harapan PH coalition. She has been serving as a Minister of Primary Industries since July 2018 after Pakatan Harapan won the Malayas general election in 2018. Fact of the case Teresa Koch is in year 2019 cases of Seputeh Malaysian politician Teresa Koch Hussin winning a defamation suit against Sharhan Humaizi Abdul Halim. He is Selangor Pasiau chief and awarded 80,000 for damages. From News Malaysia Kini is defendant Sharhan produced 2 articles referring to the plaintiff and defaming him. He said that the article post on the defendant's Facebook page had been read and received feedback from users of the social site. Readers will be consider the plaintiff to be anti-Muslim, racist and have negative implications for his reputation as a politician. The judge said the court did not agree with the defense of the defendant that Koch was anti-Islam after alleging Koch and DAP were against Jawi writing on road signs and gave support to a beer festival held in Kuala Lumpur. Despite there being freedom of speech, Muhammad Fairuz, he is justice, said this freedom does not go beyond what is allowed under the law. However, Sharhan, in his statement of defense filed on 29 March 2019, alleged the first article produced by him was based on facts and reasonable political reactions against the AP, apart from claiming it did not slander the plaintiff. Sharhan also claimed he did not produce the second article apart from alleging the article was not related to Koch. This is a newspaper and article of newspaper from Malaysia Kini and article The Age Market. After that, the cases relate to communication law. It is Definition Act 1957. It is the article published by the defendant, refers to the plaintiff, and that the words written was slander. Next, acts of sedition that lead to the mention that defamation and sedition which is an offence of law. In these cases, the articles post on the defendant's Facebook site and had been read and received feedback negative from the social site users. The readers would find the plaintiff as an anti-Islam, racist and gave negative implications on her reputation as a politician. Next, the right to freedom of expression is a fundamental right under Article 10 of the Federal Constitution under its simple title, Freedom of Speech, Assembly and Association. The court considered the freedom of speech is enshrined in the Constitution, but the right is subject to the law, especially the Sedition Act, said Feroz, who also ordered the defendant to pay 10,000 in cost to the plaintiff. Then related to the cases is related Article 7 Clause 1 B, which a person who has published words alleged to be defamatory of another person may, if he claims that the words were published by him innocently in relation to that other person, make an offer of amends under this section. In the case, Sharhan Humaizi, Abdul Halim published article, had written and uploaded an article entitled Ucapan YB Ustaz Halil Benar, DAP Jangan Kurang Ajar, in this Facebook account. Then the defense of the defendant that court was anti-Islam from defamatory. It is Sharhan, defendant charged with paying damages of 80,000 for defamation claims near the plaintiff.
My name is Shafinah Binti Othman, and my matrix number is 118080. Okay, today I'm going to discuss about the case of Muhammad Hafiz Muhammad Nordin versus Eric Paulsing on 2018. Okay, the background of the case, the plaintiff is the executive director of Lawyers for Liberty, a human rights lawyers non-governmental organization and a well-known human rights lawyer and activist in Malaysia. The defendant is a member of the Pertubuhan Ikatan Muslimin Malaysia, ISMA, a non-governmental organization established in 1997. ISMA's main focus is Islamic propagation in the country. The High Court found that the plaintiff had failed to prove that the impugned statement was defamatory, as he had failed to prove that his reputation has been adversely affected and tainted. The High Court also dismissed the defendant's defense of justification and fair comment. The relation to communication law on appeal, the Court of Appeal found that the impugned statement is derogatory, calculated to incite hatred and anger amongst the multi-religious groups and ethnicity in Malaysia. The impugned statement not only described the plaintiff as a fraudster, a liar who incites hatred of the Islamic religion, but also a person funded and supported by foreign entities such as the United States of America and the European Union. In the natural and ordinary meaning, impugned statement meant and was understood to mean by reasonable and ordinary readers of the article that the plaintiff is anti-Islam. Therefore, taking the main and the antidote of the article published, the defamatory statement had only one purpose, that is to tarnish the plaintiff's character and reputation. And the Court of Appeal granted damage of 100,000. And what I see here, it relates to freedom of speech and defamation. Law related to the case, This case is related to Defamation Act 1957, Item 17. Okay, one of the terms in defamation lawsuit is statement. A statement needs to be spoken, and it will be slander, and written it will be libel, or otherwise expressed in some manner. Because the spoken word often fades more quickly from memory, slander is often considered less harmful than libel. These statements are especially damaging if they involve a public or private individual and sexual misconduct or the abuse of minors. And this case was libel because the platform used is Facebook and Twitter. Generally, in order to win your lawsuit, you must show that someone made a statement, the statement was published, the statement caused you injury, the statement was false, and the statement did not fall into a privileged category. For the conclusion to this case, a person filed a counterclaim in October the same year against Ismail and Hafiz for publishing the article "Jangan Biar Eric Paulson Bebas Tanpa Perbicaraan." Do not free Eric Paulson without trial on its website, implying that Paulson was a liar and instigator. The Court of Appeal found that the statement by the defendant, Mohammed Hafiz Mohammed Nordin, was defamatory, and lawyer Eric Paulson wins 100,000 damage in defamation suit.
My name is Maisarah Binti Ismail. My matric number 1180181. I will discuss about Alvin Tan and Vivian Lee. Fact of the case. Alvin Tan, or his real name Tan Jie, and his girlfriend Vivian Lee, or her real name Lee Mei-ling, were both from Chinese races. Alvin Tan and Vivian Lee were 25 and 24 years old. They had uploaded a post on their Facebook page, a picture of the both of them eating bak kut teh, that a popular pork dish in Malaysia, which is non-halal, with a Ramadan greeting, "Selamat berbuka puasa," dengan bak kut teh yang enak, wangi dan menyelerakan, on July 11, 2013. In addition, they put a halal logo on the left bottom corner of the picture. In his posting caused the anger of Malaysians, especially Muslims. They pleaded not guilty to the charge but will be jailed without bail in Malaysia. During the trial, which began on November 2015, only Lee Mei-ling present at the court while Tan was fled the country. Next, relation to communication law. The authorities are taking this case very seriously as it casts doubt on the value of freedom of speech in the conservative countries. Their action can lead to feeling of hatred, anger, disunity among the Malays and Chinese, and also undermine social harmony and public order. In this case, Alvin stated that the post just was hilarious, but it has touched the sensitivity of Muslims on social media. This action was contrary with the Article 10, the freedom of speech in Federal Constitution. Next, law related to the case. Several restrictions have been imposed to limit the scope of a citizen's freedom of speech in accordance with the law in Malaysia, including the Sedition Act 1948. In this case, Alvin Tan and Vivian Lee posting seditious material through the offensive greeting toward Muslims. They were charged under Section 4, Clause 1, Clause C of the Sedition Act 1948, which carries a maximum fine of 5,000 ringgit or 3 years jail, or both if convicted. In addition, in Article 10, provide that citizens have the freedom to express their opinion as long as they do not touch on the sensitive issues that have been identified in a federal constitution. The conclusion of the case, Al-Bintan was sentenced in absentia as he is believed to have fled to the United States. In April 2018, the High Court set aside the jail term imposed on Vivian Lee and instead fined her 5,000 ringgit over a Ramadan Bakute Facebook post which sparked nationwide uproar 5 years ago. Vivian Lee, who is the ex-girlfriend of former sex blogger Al-Bintan, was originally ordered to serve 5 months and 22 days jail by the Session Court in May 2016, but she appealed the sentence. Lee to serve 6 months jail if she failed to pay the fine, and Lee paid the fine.